What are non-competition clauses in employment law? I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. Non-competition clauses in employment law are often viewed as the big bad of restrictive covenants that might appear in a contract of employment or a settlement agreement. What they typically tend to do is prevent employees from working with competitors of their employer or offering goods or services in competition with their employer for a limited time after the employee has left the employer's employment. So this typically tends to be 6 or 12 months after the employee has left their employment. Now, for these kinds of clauses to survive, to be legally applied, they have to be reasonable and justifiable. Therefore, it follows that they are the most difficult restrictive covenants for an employer to enforce through the courts, as the employer has to prove that those restrictive covenants, those non-competition clauses, are necessary, which can be very difficult to do. At the same time, on the flip side, for the employee, this does not give the employee carte blanche to go around breaching non-competition clauses, because it's key to remember that they might still be legally enforceable. So be very, very careful of them. I hope that's answered the question. In the meantime, if you're finding a settlement agreement hard, bring it to Richard.